So last week, we did the Alien Tort Statute. So from that, you see it's a very broad statute, and it was really in the 80s, had its heyday, like 80s and 90s. Any foreigner could sue any foreigner, and they would impose decisions against that individual, even if they weren't in the US. It was interpreted very broadly, and it really opened human rights lawsuits in the US. What has happened, and this is the reason I went through the case law, because as I said, in the US, everything is precedent. Everything is decided by case by case. We had a decision that restricted it. First, it became with restrictions on suing corporations. So it became very focused on just individuals suing each other. And then we had a dissenting opinion. And one of the things, a supporting opinion by Neil Gorsuch, which stated that the US court should not become a place for foreigners to be suing each other. So that was not part of the main decision, but that is something to keep in mind, because you have a very conservative court right now. And if your case reached the Supreme Court, it's very possible that at this point, it would not go forward. The decision would not be found in your favor, because there's a justice who has expressed a view of wanting to restrict the ability of foreigners to sue foreigners. It has not been there has not been any official decision saying that, but it was a supporting opinion, which isn't part of the decision, so isn't the final word on it, but it carries some idea and concept of what's coming down the line, that there's going to be challenges, and that the Alien Tort Statute is going to be restricted under this very conservative Supreme Court. So what are the other options? The next option that we're going to look at is the Torture Statute. I'm just going to open the other. You don't see it. So the Torture Statute has a number of challenges as well. And that is a time one. It's very difficult. The crime has to have occurred since the Torture Statute was passed. So 20 years ago. We have had cases of war crimes in Liberia that a number of Liberians have come here and tried to prosecute, working with different NGOs. They've tried to file suits against sitting officials in Liberia in Africa, and it has not been allowed because the crimes occurred more than 20 years ago. Just move this thing. So the law criminalizing torture states that whoever outside the United States commits or attempts to commit torture shall be fined under this title or imprisoned for not more than 20 years or both. And if death results to any person from conduct prohibited by this subsection, shall be punished by death or imprisoned for any terms or years of life. So torture is defined as an act committed by a person acting under the color of law, specifically intended to inflict severe physical or mental pain or suffering upon another person within his custody or physical control. It prohibits torture committed not only by US citizens, but by non-US citizens who are present in the United States. There is jurisdiction over the activity if the alleged offender is a national of the United States or the offender is present in the United States. So it doesn't matter. So one of the nice things about this is that usually you see torture being prosecuted, for example, at the International Criminal Court. This is actually a statute that allows you to go after one individual for an act. So if you can prove that in detention in a center in anywhere, in Russia, in Bosnia, anywhere, that torture was committed, you can bring that case to a United States court if that individual is in the US. So if you have somebody who's traveled here on vacation, who's visiting family, who's here on business, you can bring a suit against them. That is more restrictive than what we saw with the Alien Tort Statute, where there's not a requirement of presence in the US. However, this allows you to not just bring a suit for money, you can actually get the person here imprisoned in the United States for the crimes that they committed. So it all begins, it came into effect in 1994. So anything that occurred prior to 1994, so the first Liberian Civil War was in 1993. So it fell outside of the torture statute. So you have a time restriction, and you also have a restriction of the individual being in the United States. So this torture statute has not been used a lot in the US. It's very infrequently used. It usually requires you to go through the federal courts. It requires you to have work with a US prosecutor in a federal court. And that may sound challenging, but it's not. I worked for an NGO, and our entire job was pushing US federal courts and US attorneys. US attorney is a federal prosecutor in each of the different sections of the United States. So we worked with the Pennsylvania US Attorney's Office, which is a federal prosecutor, to prosecute Liberian cases. The NGO I was working with only worked on prosecuting the crimes there. All that this involves is introducing yourself to the federal prosecutor. So if you become aware that somebody who's committed torture in Russia has a vacation home in Florida, you find out which division of the federal court systems that house, that address falls under, and you reach out to that prosecutor. You can do that by partnering, and I will, at the end, if anybody wants, list NGOs that work with foreign NGOs. You partner with them, and they will go and they will approach the U.S. attorney in that jurisdiction, and they will start to open a case. Second option, you work with the NGO or you do it yourself. The United States government, the Department of Justice, has something called the Human Rights Special Prosecution Office. The Human Rights Special Prosecutor is a very close friend of mine. We worked for 10 years together. She was at the Yugoslav Tribunal for 10 years. Brilliant woman. She will work with you. She has a team that is divided into different groups. So you have a group that's working on Africa, you have a group that's working on European cases, and they will partner with you, and they can make that introduction to the US attorney. So they actually are sort of, I don't want to say that the US Attorney's Office answers for them, but the US Attorney's Office is intended to and is supposed to partner with them. So what you would do is you would go to contact, her name's Teresa McHenry, and I can send emails. You would contact her office and you would say, I have a case against this person. I'm aware that they're residing in Pennsylvania, in Florida, in New York, and I believe that there's enough to bring something under the Torture Act. And then that office, the Human Rights Special Prosecutor's Office, is obligated to review your case and then to take it to, if they feel that there's a substantive case there, to take it to the US attorney in that jurisdiction. So there's two options. You go to the Human Rights Special Prosecutor and they can bring that to the US attorney's notice in the jurisdiction, or you go to an NGO, a US NGO, Human Rights First, Human Rights Watch, the one I worked for, the one in San Francisco, Center for Justice and Accountability. You go to them and they bring that to the attention of the US attorney. What's the difference? If you go to the Human Rights Special Prosecutor, there will definitely be a more conservative approach taken. The entire office are lawyers. Within each team, there is one historian, they call it. A historian in the US government is basically more of a political analyst. That's somebody who will really be familiar with the political, they'll be fluent in Russian, they'll be aware of the political situation there, and they will discuss that with the lawyers, but you're definitely get a much more conservative, well, we don't really see this as a strong case, so we don't recommend going forward. Whereas if you go to an NGO, they will be creative. They will be much more creative. They'll be like, okay, we're going to help you and we're going to help you build this case. Of course, if they believe that there's no way to go forward, they'll say that to you as well. But if they think that you have a valid case, they're going to be less confined by US government lawyer mentality. They're going to be much more creative. And the second step for them will be to partner with a US attorney that they think will work with them. So the group that I worked with, Civitas Maxima and Center for Justice of Accountability, were aware of a number of Liberian war criminals who committed torture in Liberia, living in Philadelphia. We were able to go forward because the US attorney, the assistant US attorney in Philadelphia, worked on the Srebrenica case at the ICTY. So for 8 years, he was a war crimes prosecutor, and he knew how to bring a case. He knew how to bring a number of witnesses from Africa, how to prepare those witnesses, how to build that sort of case. At the same time, we had information about a serious perpetrator of torture who was working as a security guard in a government building in Baltimore, Maryland. We contacted the assistant US attorney in Baltimore, and he had no interest. He was scared by the international element. He only wanted to do his kind of gun cases that are happening in federal courts, and he refused to meet with us. So it's something you have to be aware of, is that every jurisdiction is different. Every US attorney's office is different. And one of the good things about partnering with either our HRSP, Human Rights Special Prosecutor, or an NGO is that they are going to know which US attorney's office is going to cooperate with you. I'm going to get to this later, but there's a case in Colorado, a Torture Act case, and that was all created because the Human Rights Special Prosecutor became aware of an individual who committed torture living in Colorado. And the Colorado office was very receptive, the US Attorney's Office. And now one of the biggest torture cases is being brought in Colorado. So this is possible, but you really need to partner because as for an NGO, even me, like I mean, now having worked in this area, I know where the US attorney's offices are creative and where they want to get involved in international cases. And I know where, where, like, for example, in Baltimore, Maryland, where they have no interest. But there's many, I don't know what's happening in Florida, for example. I don't know what the US attorney's offices are like there. So you would have to partner with groups that do know that. So I'm very happy to reach out and make connections with NGOs and also with the HRSP. I know HRSP has a team working on Russia, so that's something to keep in mind. Again, keep in mind also that that office, unlike NGOs, is filled with US government lawyers. So they are very conservative in how they approach cases. So it's much harder to get them to push for a case than it is an NGO. So I'm now going to go through some of the cases that were, Zoom is making me crazy, that were brought in US courts. So going back to Liberia, we're going to look at one of the first torture statute cases. And it was the case of the United States government versus Chucky Taylor. I don't know how many of you are aware of who Charles Taylor was. He was president of Liberia. He was prosecuted for war crimes in Sierra Leone. His son, Chucky, was also involved in those crimes, and he was a resident of Florida. So during the reign of Charles Taylor, there was numerous the very well documented crimes committed, torture, crimes against humanity. They were carried out by the anti-terrorist unit, which fell under Charles Taylor. And this was an elite personalized military force that was led by his son, Chucky Taylor. So Chucky Taylor there was two ways that the US government got him. The first way, he's a US citizen. So he has US citizenship. So even if he was residing somewhere else, he would be able to be charged under the torture statute. But he was also resident in the United States. He was arrested in Florida. I don't have exactly where, because that would be able to, we would know then which US Attorney's Office. So just quickly to interject, the United States system of federal prosecutors, you have the US Attorney that's based in Washington. And many people don't know this, but the US Attorney's Office falls under the executive branch. Even though it's a judicial, it's going through the courts, the US Attorney's Office is not under the judiciary. So we have administrative, executive, and judiciary branches of the US government. The Department of Justice falls under the executive. The center for this is Department of Justice is in Washington, but that is the head. He's the boss there in DC, but he underneath that in every state, depending on the size of the state, you have 2 or 3 US attorneys. And they are also appointed by the president. So the attorney general, and I think we're still waiting for that appointment by Biden, and then each of the offices in the United States in each area. So Pennsylvania has 3. So our district, there right now we're awaiting, I know who's been nominated. We're waiting for that appointment by President Biden, and then that person will appoint and rearrange his entire office. So this is a little bit, political. I have to say, up until Trump, you didn't feel it as much. The U.S. attorney in our federal court, in our federal Philadelphia area, was a very strong Trump supporter, and he was gearing his cases to support Trump's strategy and what Trump was trying to achieve. So now we're going to have a whole new thing. We're going to have a U.S. attorney who's supported by Biden, and you're going to have U.S. attorneys in each district in each state who have been appointed. So that's something to keep in mind, that now it's a very, it's a great time to be bringing human rights cases. You would never go directly through DC. You might go through HRSP, the Human Rights Special Prosecutor's Office in DC. But what you're going to do is look, where is the individual I'm targeting, where is he residing, where does he own property, and what U.S. Attorney's Office does he fall under? So in 2006, Chucky Taylor was arrested in Florida for attempting to enter the United States under a falsified passport. So oftentimes you're going to see in these cases, and we're going to come, the cases that I worked in in Liberia were under immigration statute. Here, the arrest was under a fake passport. So he was detained for some months and criminal charges were filed against him. So even though the arrest was made because he came in under a fake passport, he was charged while he was detained for torture and conspiracy to commit torture. In pursuit of filing a suit, the group that I used to work for in San Francisco, Center for Justice and Accountability, began investigating. And they represented an individual who was personally tortured by Chucky Taylor. So this is the role of US NGOs. They will find and support the US government prosecutors, and they will bring witnesses. They will try to locate other individuals and bring them to the attention of the US Prosecutor's Office. So we do have a very strong tradition in the United States of US attorneys' offices, US federal prosecutors working with US NGOs. And for example, my former group, Civitas Maxima, was a Swiss NGO. So they are open to working with international NGOs. It is best, though, if you partner with a US NGO only because they have the familiarity and they know the actual individuals, their personalities, and who best will cooperate with you. So the CJA went on to support the US federal government's efforts to prosecute him under a US extraterritorial torture statute, which makes it a crime for any US citizen or any individual of any nationality who's present in the US. It's illegal to participate in torture abroad and can be prosecuted for committing or participating in torture abroad, regardless of the nationality of the victim. So as long as this individual is in the US, or if they hold a US passport, if they've tortured individuals in another country, and those individuals are all Russian, those individuals are all Liberian, it doesn't matter. They can be prosecuted in a US court. On January 9th, 2009, so 3 years after his arrest, Chucky Taylor was sentenced to 97 years in prison. He is still serving that term in Florida. He was, up until now, the only person ever to be prosecuted and convicted under the US extraterritorial torture statute. One thing about the US, and you're going to see in the other legal techniques to bring people to suit in the US, is that we give really nice big sentences. When we study universal jurisdiction, you will see that when a case is brought for somebody for committing crimes in Syria, horrible crimes, mass rape, torture, they're being given 6 years, 8 years. In the US for whatever. We're going to see now, if you use immigration as a tool, you will get large sentences that range between 30 years and the life sentence, which I think is and one of the strong suits of the suing in the US court. And the other one is that these are swift decisions. From arrest in 2006 to trial, numerous appeal cases, it was a full, actually only 2.5 years. And the trials are always 2 to 3 weeks. So it is swift, and the sentences are very, I believe, appropriate to the crimes that have been committed. I'm just going to make sure that I am flipping the right pages for you guys. That was the Chucky Taylor case. So this is the US torture statute. Okay, and then the second case that I'm going to discuss, which is a case that's going on right now, is the United States versus Michael Correa. Michael Correa is a 41-year-old who was alleged member of a notorious death squad in Africa. And he committed torture by torturing people to give confessions and forcing them and beating them, that resulted in numerous deaths. How does the U.S. know about this? How did the U.S. government get evidence of this? He's Gambian, and there was a Truth and Reconciliation and Reparations Commission in Gambia. And it was found that Correa personally tortured individuals or was present when his military group engaged in torture. So the US was able to take material from the Truth and Reconciliation Commission, which means statements, evidence, and bring it to his prosecution in the US. Truth and Reconciliation Commissions, as many of you know, They find out who did these bad things, they list them. Oftentimes there's absolutely nothing happens after that. There's no ability to actually prosecute this individual. For example, Liberia had a Truth and Reconciliation Commission where people were named, lists were made, all of the crimes were detailed, but those individuals were allowed to run for government. And many of those people are now, even though they were found to be guilty of crimes in Liberia, are now sitting as governors and commissioners in the government of Liberia. So if anything, Truth and Reconciliation Commissions can provide evidence for lawsuits brought under universal jurisdiction or under US law. So in 2006, the Gambian National Intelligence Agency report on interrogations following the attempted coup implicated Correa in torture. And that entire intelligence document was handed to the Truth and Reconciliation Commission. On September 17th, 2019, so just recently, the US Department of Homeland Security arrested Correa in Denver, Colorado for overstaying his visa. Again, unless you are able to go immediately and provide the U.S. Attorney's Office or the NGOs with evidence of your individual's crimes, oftentimes your actual arrests and the triggering moment of opening a case against somebody for torture comes from something stupid. It comes from a fake visa. It comes from overstaying a visa, a fake passport, overstaying a visa, lying on your immigration forms. So whenever you enter the United States, if you're applying for asylum, you have to list whether you've been involved in a military or government abroad. Have you committed war crimes abroad? And if you lie and you say, no, I never committed war crimes, of course not. If any document comes to the US government showing that you have committed torture, that you've even held a military or a political position in your country, then the US can begin an immigration fraud case against you. And by arresting you under immigration fraud, they can make that decision. Are we going to go forward and use the torture statute and really go, and build an entire case against torture? So look at those loopholes, look at what violations could have occurred. Somebody who's a criminal in their home country usually is a criminal everywhere. They're usually going to try, the number of the Liberians that we worked here had already been arrested for not small things, but, possessing guns or some sort of financial fraud in the US. So it's very easy to get somebody arrested on something small. And while they're being detained, build and bring a big case and work with the U.S. Attorney's Office. One thing to be aware of, U.S. Attorney's Office can build a case after they've indicted somebody. So you can bring a certain amount of information to the attention of the U.S. Attorney's Office. They can hold a grand jury, and the grand jury and the prosecutors can convince the grand jury that there's a case to be brought against this person so that they file an indictment. They don't feel that that's sufficient evidence to bring a case. That indictment is sealed. That indictment can be in different jurisdictions, but it can be sealed for 6 months to 1 year. So that gives the U.S. Attorney's Office approximately 1 year to build a case against that person. So let's say in a case of a Russian who's has his vacation home in Florida, you can have a sealed indictment there where that individual cannot leave the country. He may not even be aware of it, but there's no way he can go in and out of the country because there's an indictment against him. When the U.S. Attorney's Office feels that they've gotten witnesses together, they've built the documents, when they feel that that's completed, then they can unseal it and it becomes public. And that individual is then alerted. He can get his lawyer. He becomes aware that there is a case against him and that he's going to be going to trial. So there's, I don't want to say wiggle room, but there's time. There's time for NGOs and in foreign NGOs and domestic NGOs, as well as private law firms, to work with the U.S. Attorney's Office in building these cases. So that's, I think, another thing that Unlike with going to the European Court of Human Rights, where you have to present your case as it is, you have to have that all ready to go. The US does give you some time to build and to work on building a case for prosecution. So even though Correa was arrested for overstaying his visa, a coalition of human rights organizations, when they saw his name, brought together his victims. So Center for Justice Accountability, the African Network Against Extrajudicial Killings, the Gambian Center for Victims of Human Rights, the Guernica Center for International Justice. They're actually based in London, so it's an international effort. Human Rights Watch, the Solo Sandeng Foundation, and Trial International all got together, and they began to investigate, compile the statements, build a case so that they could present it to the US Attorney's Office and show credible allegations of grave international crimes committed by Correa in Gambia. They not only went to the United States Attorney's Office, they also, the NGOs brought together the case, and they approached US Senators Patrick Leahy and Richard Durbin to urge the United States government, to urge the US Attorney's Office to investigate Correa, and if warranted, to prosecute him. So on June 11th, 2020, the US Attorney's Office for District of Colorado announced that Correa was indicted. He was indicted on 6 counts of torture and 1 count of conspiracy to commit torture. Following this announcement, the Gambian Ministry of Justice issued a press release in support of the indictment. The indictment alleges that Correa and other members of his group, they were called the Junglers, severely beat the victims with plastic pipes, with wires and branches. They suffocated victims with plastic bags. They dripped plastic and acid on their bodies and subjected them to electric shock. The Center of Justice and Accountability currently represents victims of Correa in this proceeding pursuant to the Crime Victims' Rights Act. Correa's indictment represents the first prosecution of a member of the Gambian death squads, and it's the first prosecution in the world. So there was no court, special court like for Yugoslavia or Rwanda set up for Gambia. The ICTY has not, the International Criminal Court has not brought a proper case against them. They've opened investigation, but they haven't brought a case. So the first case being brought for what happened with these death squads in Gambia is actually happening in Colorado, the state of Colorado in the United States. He's the 3rd person to be charged under the torture statute, and it allows federal governments to prosecute anyone, again, who committed or attempted to commit it or conspired to commit torture abroad, as long as the perpetrator is present in the US or is a US citizen. Another individual who was prosecuted under this was a man called Suleiman Mujagic, who was a Bosnian, and he was allegedly committed crimes during the Bosnian War, and he was extradited to Bosnia-Herzegovina and was sent back there to stand trial. So once they found that he had that, there was an agreement with the Bosnian government, and as many of, I don't know how many of you know, but many of the courts in Bosnia are actually set up under the United States codes to prosecute war crimes. So it was found more appropriate for him to be standing trial in Bosnia. But both Chucky Taylor and Correa were both prosecuted here in the United States. One thing to remember about the torture statute is that nothing that occurs before 1994 can be brought forward here. And there's an 8-year statute of limitations. So that's something else. So in terms of getting the evidence and bringing witnesses, it has to have happened 8 years from the time that you're going to be bringing the case to the United States Attorney's Office. Now we're going to move on Actually, why don't we, Victor, what do you think if we take now a 10-minute break before we do torture victim protection?
Yeah, that sounds good.
Okay, let's take a 10-minute break, and then we'll come back and we'll discuss a third way to bring a case in the United States courts. It's called the Torture Victim Protection Act.
Sounds good.
Great. So the Torture Victim Protection Act. This is, let me just move all of these. Keep getting the Zoom blocking on my. So it was passed in 1991 and signed into law by President George Bush. The TVPA gives rights to US citizens and non-citizens alike to bring claims for torture and extrajudicial killing committed in foreign countries. It's similar to the Alien Tort Statute in that it allows for the filing of civil rather than criminal claims in US courts, meaning that suits can result in monetary compensation to victims rather than any jail time. So as we just saw in the torture statute, that is a federal law, and it results in a prosecution that results in it's a criminal prosecution, so it results in jail time. You can also be fined, but you also have a punitive element of jail or some sort of detention number of years. So the Torture Victim Protection Act and the Alien Tort Statute both result in financial compensation. So if you were bringing a lawsuit against somebody based on the Torture Victim Protection Act, you would be asking for a sum of money, be it, what are the damages this individual tortured and ruined the lives of 8 families. That could be a $50 million reward to be divided among the families. So again, to the tort, which I think all of you know means a bodily harm, a harm to an individual. So Alien Tort Statute and Victim Protection Act are both financial compensation, not criminal prosecution. The Torture Victim Protection Acts can be filed against individuals who, in an official capacity for any foreign nation, committed torture or extrajudicial killings of victims of any nationality. The plaintiffs can be either US citizens or non-citizens. So the crime and the individual can be from one country, and the person who's suing them does not have to be a US citizen. But the defendant must be acting in an official capacity, or at least appearing to act in such capacity. Therefore, the Torture Victim Protection Act is to address government official or military official. So no corporations, no crazy individual committing his own crimes. This is really an act that's addressing people who are in official positions. The crimes in question must be either torture or extrajudicial killing. That is the killing of a person by governmental authorities without the sanction of any judicial proceeding or legal process. Plaintiffs also need to show that prior to bringing the lawsuit before a US court, they've attempted to find redress in the country in which the crime was committed, and that country lacked adequate and available remedies for the victims. So in this application, it's very similar to the European Court of Human Rights when you use the Torture Victim Protection Act, in that you have to exhaust your own court system. Now, what does that mean? Does that mean you have to go through every level of a Russian court? No, it doesn't. It means that you have to prove that in Russia, you have attempted to bring this case and it was immediately rejected, or it went forward, but no evidence was examined. You have to be able to show that you're not going to be able to really bring this case in your country. It is not in the exhaustive way that European Court of Human Rights demands. So the European Court of Human Rights demands that you go through every single level of your court systems and that you really show that you've exhausted completely your national court. And with the Torture Victim Protection Act, you just need to show that the court is not willing to listen or to take your case or that they're not able to, that they don't have the proper structure to listen to and give the remedies to the victims of these crimes. Actually, I'm going to start first very quickly giving you just a brief summary of cases that came before the Moses Thomas. And the very first case that this was prosecuted, that this act was used to prosecute, is with torture by military forces in Guatemala. And it was brought in 1992. So the law was passed in 91. In 92, a nun, Sister Diana Ortiz, sued a former general and minister of defense in Guatemala, Hector Gramayo, contending that as command of authority, he was responsible for abduction, rape, torture by military forces in Guatemala. In 1995, a federal court in Massachusetts ruled in her favor, and she was awarded $5 million in damages. Second case was Mohammed v. Palestinian Authority. The U.S. Supreme Court unanimously ruled that the in this case, it was a bringing of a lawsuit by the Palestinian, an individual sued the Palestinian Liberation Authority for his torture, imprisonment, and extrajudicial killing in the West Bank. The court decided that the suit had to be brought against an individual, so that you can't sue a government, you can't sue a ministry. It has to be a specific individual in that ministry, in that government. So there has to be that link and that tie to an official person, but you can't bring a lawsuit against a large, an entity. Thomas Moses case. On February 2018, Center for Justice and Accountability brought a case against a man called Thomas Moses. Now, I was involved in this case, so I can give much more specific details on how they approached it. So CJA is a non-governmental organization that works with numerous different victims groups, does not just Africa. But in this case, they were working to bring a lawsuit for people that were killed in Liberia. It was a horrible murder. It was led by military forces under a man called Moses Thomas. And on July 29th, 1990, he locked up, I think, 300 individuals in a church, in a Methodist church in Liberia, and then torched it. And all of the individuals were murdered. In this suit, first of all, Thomas Moses was in the United States, so he was working as a dishwasher in a restaurant in Philadelphia. He was a former colonel, though, in Liberia, and he led the forces who were involved in that attack on the Lutheran Church. Sorry, I said Methodist Lutheran Church in 1990, and he moved to the United States in 2000. So it was not a difficult trial to bring, because he was present in the U.S. and he was, I think, a U.S. resident. He did not have citizenship, but he had a residency. He had a green card. So the case was filed first in the United States District Court for the Eastern District of Pennsylvania under the Alien Tort Statute and Torture Victim Protection Act. First thing to note is, what did the NGO do? The NGO partnered with the victims. It gathered the victims when it found out that Thomas Moses was living in Philadelphia. They were able to gather a number of victims who were resident in Philadelphia and who also named victims and witnesses who were in Africa. What was the second step that CJA did? They partnered with a big United States law firm, DuBois Plimpton. So the NGO is able to hand off the case to a law firm where partners charge between $1,000 and $2,000 per hour for their work. How are they able to do that? Because in the United States, I think I mentioned this in the last thing, in the last session we had, in the United States, there's an obligation. Every year, a lawyer has to do a certain number of pro bono hours. So they're obligated to take these kind of cases. This is a great help for any NGO that's working in the US or partnering with the US one, because you don't need to know the specifics on how to bring the case. Even the NGO does not need to have top lawyers representing. You can partner. One other case we did at CJ, we partnered with Sherman Sterling, also a big law firm in New York City. And those top lawyers are brought on and work for you for free. So money is never an obstacle for you to be bringing a case in the US. The NGO has private funding, and the law firm is going to be giving you volunteer free pro bono legal advice. So in April of 2018, the defendant, Moses, filed a motion to dismiss the case, arguing that the statute of limitation on the claims had run out and that the plaintiffs had failed to exhaust domestic remedies in Liberia. This motion was defeated because the lawyers argued that the situation in Liberia was so unstable that survivors could not seek justice in the immediate aftermath of the massacre. So that's the proof. They did not need to go, the victims or the NGO did not need to go back to Liberia and file a motion on this level court and file a motion on the next level court. They just needed to show the status and the condition and the willingness of the court to take on these cases, the domestic court to take on these cases. The court allowed the plaintiffs under the Alien Torture Statute to proceed. And after finding that the allegations sufficiently touch and concern the United States, they allowed the case to go forward. So in March of this year, the NGO and the law firm filed a motion for summary judgment supported by evidence developed after a 7-year investigation by the NGO. The motion argued that the record developed in this case makes it clear that the individual, Moses Thomas's responsibility for the massacre, and it requested that the court find him liable for torture, extrajudicial killings, war crimes, and crimes against humanity. This lawsuit was the first case to hold a member of the armed forces of Liberia responsible for abuses committed during the Civil War, and to confront a high-ranking commander for perpetrating one of the largest civilian massacres in Liberian history. So again, these cases that managed to get into the US courts and managed to be prosecuted here are historical. When there's no international court willing to take them on, US courts, there is the vehicle of the US courts, so that you can actually create a historical document of what happened in that country. One of the things with these cases is that they are presenting the statements of victims. They are presenting all of the material that supports these alleged crimes. If there's no court that's willing to hear this, perhaps in the future, there will be a court for Liberia. Perhaps in the future, the International Criminal Court will look at what happened in Liberia. And if that does happen, you have a record that's been established in United States courts that has been part of a decision made by United States courts. So it's very strong evidence that can be put forward in an international court if it ever goes there. But if it doesn't go there, at least at this time, you have a record being established of historical crimes and a punishment. The court found in this case that that federal courts do have the right to determine whether the Alien Torture Statute is involved, but they invoked they did find that they could have used the Alien Torture Statute in this case, but they decided to apply the Torture Victim Protection Act. They used also used in his case the fact that he was also fraudulently in the United States. So that was another way to hold him for trial. So he was unable to travel, he was unable to leave at any time prior to this. I don't have the exact number, but I believe that the award was $10 million they found in favor of the victims of this case. And this was done here in a US court. So Thomas Moses, as much as I would love to say this case is finished and that the victims have been rewarded for their efforts in getting justice, they Thomas Moses does have a right of appeal. So it is possible that this case will go all the way to the Supreme Court of the United States. Torture Victim Protection Act was also used in the lawsuit brought against the Saudi family by the fiance of Khashoggi, the journalist who was killed. He was a journalist with the Washington Post. He went into the Saudi embassy to get the papers necessary for a wedding license in the Saudi embassy in Turkey. And from all evidence that has been presented, members of the Saudi government murdered him, tortured him, murdered him, and he never exited the embassy. So his wife, his fiance, has brought a suit in the United States courts. The suit is pending. This is just beginning. They filed. So they're going to be filing under TVPA for torture and extrajudicial killings of Khashoggi by the Saudi government. So again, the things to remember with Torture Victim Protection Act is it has to be somebody who's acting under the authority of a foreign nation. So when Khashoggi went into the embassy, it's essential that they're able to show that the individuals who murdered him, and they do have evidence of that because there was, I think the Turkish government was bugging. They had listening devices in the embassy, that those were officials that were sent by the Saudi government to kill Khashoggi because he was a member of the opposition and was writing against the Saudi government and the Saudi prince. So they have to be able to show that the first people who murdered him were part of the foreign government. So a non-state actor cannot be sued. So an individual just working and just murdering, even though he might be supporting a government philosophically or very loyal to a government, he can't be prosecuted under TVPA. That individual has to actually hold an official position in a government or in a military. And secondly, they have to exhaust, that you have to be able to show that the court is either not adequate or not able domestically to take on this case. Third, while corporations, again, are exempt from liability under the TVPA, they can be sued under certain conditions under the Alien Tort Statute. It's been difficult, but you would never bring any suit against a corporation under the TVPA. And finally, remedies only can be financial. There's no punitive. You can't be, there's no criminal element of putting them in jail, punishment. So the two statutes for torture vary because one is a criminal one and this one is the civil one. So the Foreign Sovereign Immunities Act was passed in 1976. It's the primary means for bringing a lawsuit against a foreign sovereign or its agencies and instrumentalities. The act establishes certain procedures that have to be followed when suing a foreign sovereign and attaching property for international debt recovery purposes. Under the act, foreign states have immunity from litigation, although there are exceptions. Under customary international law, a foreign state is immune from the jurisdiction of the courts of another foreign state. Until recently, there were very few exceptions to this rule. However, as governments began to conduct commercial activities between themselves on an increasingly frequent basis, complete sovereign immunity gave state governments an unfair advantage in commercial dealings. Exceptions were created through the Foreign Sovereign Immunities Act to provide judicial remedies, including enforcement of arbitration agreements to private parties dealing with the state in commercial activities. When does a state not have immunity under the Foreign Sovereign Immunity Act? So you cannot sue another state in US courts, but there's certain times that we can. Number one, the foreign state waives its immunity explicitly or implicitly. Almost never happens. Two, commercial activities by the foreign state involve or directly affect the United States. Three, property taken in violation of international law is at issue. 4, rights in U.S. property acquired by succession, gift, or rights in a movable property situated in the United States are at issue. Money damages, number 5, are sought against a foreign state for personal injury, death, or damage, or loss of property by tortious acts or omissions. Enforcement of an arbitration agreement made by the foreign state with or without a private party. Money damages are sought against a foreign state for personal injury or death that was caused by an act of torture, extrajudicial killing, aircraft sabotage, hostage taking, or if the foreign state is a designated sponsor of terrorism. So this is right here. Let me pull this up for you in Russian. This is the key. This is where the majority of FSIA, Foreign Sovereign Immunity Act cases have come in, is when the foreign government can be shown to aircraft sabotage, taking over an airplane, terrorism, when the government is acting illegally under this list of categories. So this is significant. The second to last one on the list is very significant. And the case, the sort of most notable case that was brought was the case of Marie Colvin versus the Syrian government. So I don't know how many of you remember Marie Colvin. She was a very famous journalist. She worked for mainly with BBC. She was known because she had lost her eye during one conflict that she was covering. So she always had a patch. She was very famous during the Bosnian conflict for covering the conflict there. And in the spring of 2011, the Syrians were in conflict. She was present there. She was murdered in Homs, a city, and they were able to prove that Assad directed his attack on the journalists who were covering that case, who were all in one location. The attack resulted in the direct death of Marie Colvin and her photojournalist who was with her. The lawsuit was filed July of 2016. It was again a partnership of the Center of Justice and Accountability, which is an NGO, and the family of the victim, and this law firm that I mentioned for you, Sherman Sterling, a big law firm in New York City. So they were able to bring this case and sue under the Foreign Service Sovereign Immunities Act. One very specific thing, they actually were able to go and deliver the subpoena in informing the president. They had somebody go to the presidential, from the US Embassy and serve Assad with notice that he was being sued in a US court. What was the victory for them? While they lost Marie Colvin and this horrible crime was committed, they have an award for $300 million in US courts. This is significant. Let me pull up the Russian again. This is really significant. Now, whether they're able to collect that amount, it's possible, because under this act, it is possible to seize foreign property abroad. So if Assad has property in the United States, if he owns a hotel, if he owns anything, he's able to, the US government is able to seize that and give that to the Colvin family as compensation, because of the final decision was decided in her favor for these amounts. So the Foreign Sovereign Immunities Act is a very difficult act, because it is very big deal. So it's basically, in our case, it would be the US government suing the Russian government. What are the reasons and ways to do it? We know that Russia didn't waive its immunity, a whole list of things that it hasn't happened. But if you can show that they're acting in partnership in an illegal act, terrorism is the one that's defined, but an illegal invasion, numerous different illegal international actions that are resulting in death, that are resulting in a victim then you have a chance to bring a case forward. The financial amount that you get is enormous under this act. Something to remember and always keep in mind is it cannot be in US courts, you have to have a victim, you have to have a name, you have to be suing on behalf of at least one individual. So it can't be just they acted illegally, we're suing on behalf of the Ukrainian government, just hypothetical Ukrainian government. You really have to have one individual who was affected by this act. I mean, right now this act, and the final one that I'm going to mention, JASTA, and I'm going to, I'm not sure we're going to have time. We may have time. I have a very short clip about the Colvin case that the law firm put forward. These are really used in U.S. courts and have so far have always been focused on governments that support terrorism. So in cases of the Saudi government, Iranian government, these are not cases that are usually brought against non-terrorist supporting governments. But there is, again, if you get a NGO that is willing to work with you and is willing to be creative and is willing to look at the illegality in the context of this Foreign Sovereign Immunities Act, in the context of the crime that you want to pursue, you may be able to pursue it. And courts at this moment, as I mentioned, with new judges coming in, new attorneys coming in, may be willing to go forward using this. The final one that I'm going to discuss is JASTA. And this is so far very, very, very specific. And this is something that Obama actually tried to block because it's he was the president during the passing of the JASTA Act. So what is JASTA? It's the most recent development in national prosecution of foreign actors. It was passed in 2016 and vetoed by Obama, but then it was overturned. So while the Foreign Sovereign Immunities Act allows US citizens to sue a foreign state if it's designated as a state sponsor of terrorism, JASTA allows federal courts to exercise subject matter jurisdiction over any foreign state's support for acts. So any country that is supporting an illegal act or an illegal act of terrorism, the US can pursue. So it does not require a State Department declaration. It can be based on the actions of that country. This was a very specific act that was pushed again by NGOs, families, working with a big law firm, Cozen and O'Connor, based in Philadelphia. This was allowing the victims, the family victims of the attack on the United States, 9/11, to sue the Saudi government. So the Saudi government is not declared a sponsor of terrorism, but they were allowed to sue under this new act, which looks at the subject matter jurisdiction and it looks at the actions. It doesn't look at the State Department's official classification. These cases have begun in federal court, but they're still pending. So I can't bring you official decisions, but this is, again, something to think about, is that this was passed in 2016 based on 9/11 crimes. If you're able, as an NGO, working with other NGOs and working with US law firms, you are able to pressure US senators, like the Magnitsky Act went forward. That's possible. It is possible in the US to change laws. It is possible to bring new acts. So if there's something specific, that there's some area that is not covered or you feel that needs in the region that you work in, that you can prosecute. I mean, and this is now, this is something that so I'm saying now to act separately from going through the courtrooms, it's possible to push US senators and congressmen to push for specific laws that you would want passed. And that would be very much working with NGOs and US law firms to see where is that, why are you not able to bring a case? If you see that your government is involved in a systematic acts of some sort, say hypothetically free speech, crimes in detention, why does the Alien Tort Statute or the Torture Victim Act, if they are not able to be applied to your situation, think creatively. Think the US is a country that is now open and has been for years to new laws being brought forward. Magnitsky is just one example of NGOs, victims, individuals working, families working with the US government to bring changes in the law. So that's what I'm going to leave you with, that it's not final. It's not final that you are restricted to the current laws in the US. You do have the chance and the opportunity to work with US structures to try to push for new laws and to if you can bring enough of a case of systematic behavior by a government or by individuals, you can possibly bring changes to the US laws as well.